Duane, you're refused.
Stop emailing me. Now you can't get or talk to Karter. Leave me the F alone, and that's the last time I'm going to tell you. Never to talk to his child again. We'll never know what happened. Is that really true? Quarter-inch rectangular red abrasion on the right external nair. Quarter-inch square red abrasion on the lateral aspect of the right upper lip. 1/8 inch irregular red abrasion on the lateral aspect of the left upper lip. Oblong red contusion to his cheek. Red contusion on the right chest adjacent to the sternum. 1-inch round red contusion on the midline upper abdomen along the costal margin of the ribs. 3/4 inch round red contusion on the right upper abdomen along the costal margin. Another separate distinct injury along with the cage ends. Blue-green discoloration on the midline abdomen. Red contusion on the abdomen overlying the umbilicus. 1/4 inch round squared red abrasions on the underside of the scrotum. Red abrasions on the right mid-abdomen. Internal hemorrhages reflected on the scalp. Right posterior parietal. And then another one. Multiple. Interior abdominal wall muscles, adipose tissue, and mesentery. Extensive hemorrhage. 2 1/2 inch gaping laceration of the liver, the attachment of falciform ligament. Blood in the abdominal cavity. Pancreas and hemorrhage. Testicle and cord hemorrhage. Patchy serosol congestion hemorrhage on the small intestine. But we'll never know. The medical examiners told you exactly what you needed to know. And Mr. Groove is absolutely right. You don't leave your common sense at the door. It stays with you. And common sense is that Kianna denies doing it herself, but she doesn't blame Kiyon. She defended him. And those are the only two people who had access to this child when the trained expert medical chief examiner tells you that this injury could have occurred. And her original statement that he had growing up on Sunday night, not Monday, not a convenient change in her story to Monday when Kiyon was home with him, but Sunday, when it was her or Kiyon who had access to him. Common sense. It was either one or the other or both. And her testimony was really telling. Her evasiveness, confrontational, the fact that she wouldn't even say her own child's name. This poor mother who's lost her only child, and she can't say his name in front of you. She just didn't know. She's just oblivious. She had no idea. She didn't think anything was wrong, but yet she claims that she moved to those apartments to be closer to the doctor because he has asthma and allergies, like a whole lot of other kids do. And that she's always paying attention when something's wrong. And then she calls 30 million times a day. All of that vanished that weekend. And that's exactly why she wouldn't let Kadeem see her son. His son. Their son. Now, it has become apparent to me that the defendant's main argument as to why she didn't do this is because she's had to wait too long. That's the only consistent argument that has been made. Not about the facts as to what happened to that child. There's just been argument after argument about how long it's taken the state to get this to trial without offering any real context to it. Without offering any reasons why. If there were any other issues that came up beyond the state's control. Doesn't bother bringing anything like that up. But justice has no expiration date. Karter's life had the expiration date. But this trial does not. You want a smokescreen? There it is. That's their smokescreen. Be mad at the state. Don't be mad at the two people who had custody of this child when he suffered a 2-inch laceration to his liver. Don't pay attention to that. It just took too long. That's not even what the law says. Reasonable doubt. The judge is going to tell you it's not a fanciful doubt. It's not to a mathematical degree of certainty that the state has to prove this. Alright, this is where your common sense comes into play. He did bring up motive. The state doesn't have to prove a motive. It's not a legal requirement. It is not a legal requirement that the state prove motive. Or premeditation, for that matter. And then they bring up the fact that Kiyon Benton isn't here. Well, I'm not the only person in this room with subpoena power. With the power to compel someone else to come in. So do they. You don't know the weapon. Yeah, I mean, I thought that was pretty evident from the moment y'all were sitting out there when the judge read the indictment to you. That's no secret. What we have is hemorrhaging on the head. We have multiple blunt force impact injuries to the abdomen. It could be anything. It could be anything. And you don't even have to pick what it is. Hands are the most obvious, but you don't even have to make that decision. All it has to be is an object, the nature of which. And the nature of those injuries, it is clear that a hand or other object was used to inflict them. This defense argues murder too is weird. No, not really. Not if you think about it. Not if you think about what duty a parent has to their child. Their 2-year-old child. I'm not sure if there's legal duties as it relates to, children who are 30. But a 2-year-old who relies on his mother for protection. A woman who claims that she moved close to the doctor's office. Who said that throwing up in his sleep was a red flag or it was abnormal. But then in the same breath said she didn't think anything of it while she was lying to y'all on the stand. A woman who took her child to the pediatrician all the time, who had him hospitalized, who watched his allergies, who gave him his breathing treatments when he needed. The absence, randomly, of her give a damn is telling. Yes, when your 2-year-old child is in that much pain, you have a responsibility to seek medical care. And she did not do that. Reckless disregard for how the pain that he was experiencing may affect him. And we know waiting hurt. We heard that testimony from the medical examiner. It hurt bad. I think it hurt a lot worse than she was saying. I don't think there's any way he was letting on that this was just a little stomach ache. And that caused pain and pain and more pain until he died. Whether or not you want to pick a winner and a loser, who did this, who didn't, other than Karter, who's the victim here and who's not? Whether or not she actually knew or didn't know. At a minimum, she's guilty of murder in the 2nd degree for not performing her basic duty as a mother. Feed them. Give them some clothes. They don't have to be nice. Put some kind of shelter around them. Give them some medical care. She couldn't even meet that burden. But poor her, single mother, as though Kadeem was not an active father in this little boy's life. He didn't abandon her. Didn't cut ties. He wanted to be involved in his child's life. She took that from him. She testified. She lied. She lied. I asked her if she tried to get a new phone shortly after this. She said no. And then we went through pages of her trying to get her new phone. Records that she herself identified right after this happened. Multiple pages. Why suddenly do we need a new phone? To conceal. Why brag about the fact to Miss Shirley that the original investigator is no longer on the case? She's calling. She wants more info. More info. She's worried about herself. She knew that the arrow pointed to 2 people, and she was one of them. She's terrified that the state may come down on her. And then she testifies that if you call the pediatrician's office, you can't get an appointment the same day. That a pediatrician would never have the time. As though a pediatrician would never anticipate the fact that younger kids often get sick. Simple illnesses. But they can't just be seen. Oh, I gotta wait. I gotta wait. I can't get an appointment. Never mind the fact that she's a regular. Never mind the fact that she carried on and on and on about how awful it must be for them when she's on the body cam with Officer Whitell. She didn't even make an effort. Now they make an issue of the samples on the floor. They didn't send anything to GBI. Well, Karter's body went to GBI along with that liver, along with those bruises, those hemorrhages. And what is interesting is that all of a sudden here, well, we don't know if he was throwing up or not. When she herself tells law enforcement in one of her interviews, yeah, I figured out he was throwing up. And now she wants to change her story on that. Every little thing she wants to change. She wants to fight. The question here isn't whether or not you tolerate how long it came to trial. The question is whether or not you tolerate a 2-year-old boy being murdered. That's the question. And you've heard quite a bit of testimony. Right? Remember, testimony is evidence. You heard about what was overheard by the primary pediatrics people. Don't worry about that. Just get here. Or I should have brought him when you told me to. Not sure why Mom is telling somebody else who's not biological father if she's there, like she said she was. Another man who she broke up with shortly after this, she didn't want to answer that question. She didn't want to answer anything. In fact, when I said nothing further, Your Honor, she went, thank you. A grieving mother. Common sense here. Two people had access to this child. And she says she didn't do it and that Kiyon didn't do it. Common sense tells you that statement makes no sense. They were hiding, covering up. Covering up. Whether she hit that child, whether he hit that child, at this point, it doesn't matter because one of them did it or both of them did it. But now we have the cover-up. She wants you to believe that she's such a good mother that she calls all these times a day. She always checks in. She drives from the office at lunch to get, to check on Karter while he's there. And yet she's got no idea. No idea. Ladies and gentlemen, there are plenty of pieces to this puzzle for you to see that she is 100% guilty of malice murder, of felony murder, and murder in the second degree. Thank you.
Hi, ladies and gentlemen. As you know, you are considering the case of the state of Georgia versus Kianna Renee Davis. The grand jury has indicted this defendant for malice murder, felony murder, cruelty to children, felony murder, aggravated assault, murder in the second degree, and cruelty to children in the second degree. And the indictment reads as follows. It charges her in count 1 with malice murder for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date of the offense being unknown to the grand jury, did unlawfully, with malice aforethought, cause the death of Karter Ambrose, a human being, by beating said victim with an object, the exact nature of which is unknown to the grand jury. Count 2 charges her with felony murder for that the said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date of being unknown to the grand jury, while in the commission of the offense of cruelty to children in the first degree, a felony, did cause the death of Karter Ambrose, a human being, by beating said victim with an object, the exact nature of which is unknown to the grand jury, which caused cruel physical pain, to wit a lacerated liver, and said victim is a child under the age of 18 years. Count 3 charges cruelty to children in the first degree. The said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020 the exact date being unknown to the grand jury. Did maliciously cause Karter Ambrose, a child under the age of 18 years, cruel physical pain by striking said child with an object, the exact nature of which is unknown to the grand jury, which caused a laceration to said child's liver. Count 4 is felony murder for that said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date of the offense being unknown to the grand jury, while in the commission of the offense of aggravated assault, a felony, did cause the death of Karter Ambrose, a human being, by striking said victim with an object, the exact nature of which is unknown to the grand jury, which when used offensively against the person is likely to result in serious bodily injury. Count 5 is aggravated assault for that said accused in the state of Georgia and the county of Houston between the 15th and 17th day of November 2020, the exact date being of the offense being unknown to the grand jury, to make an assault upon the person of Karter Ambrose with an object, the exact nature of which is unknown to the grand jury, an object which when used offensively against a person is likely to or does result in serious bodily injury by striking said victim with said object causing a laceration to the liver. Count 6 is murder in the second degree. The accused in the state of Georgia and the county of Houston on or between the 15th and 17th day of November 2020, the exact date being unknown to the grand jury, did commit the offense of murder in the second degree. The accused caused the death of Karter Ambrose, human being, irrespective of malice, while in the commission of cruelty to children in the second degree, by failing to seek immediate medical attention for said child for his lacerated liver. Count 7 is cruelty to children in the second degree, for that said accused in the state of Georgia and the county of Houston between the 15th day of November 2020 and the 17th day of November 2020, the exact date being unknown, with criminal negligence, caused the death of Karter Ambrose, a child under the age of 18 years. Cruel physical pain by failing to seek immediate medical attention for said child for his lacerated liver. All of these being contrary to the good order, peace, and dignity thereof. This indictment was returned by the Houston County Grand Jury on the 17th of October 2023. Now the defendant has entered a plea of not guilty to this indictment, and the indictment and the plea form the issue that you're to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to prove innocence or to introduce evidence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a doubt of a fair-minded, impartial juror who's honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it's a doubt for which a reason can be given, arising from a consideration of the evidence, the lack of evidence, or conflict in the evidence. After giving consideration to all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that's a doubt of the law, and you must acquit this defendant. But if such doubt does not exist in your mind as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of this defendant. Now, members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. Obviously, that's what I'm doing now. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence that's been presented. Then you must apply the law that I'm giving you in this charge to the facts as you find them to be. Your oath requires that you decide this case based on the evidence. Evidence is simply the means by which any fact that is put in issue is either established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits that were admitted during the trial. Evidence does not include the indictment, the plea of not guilty, the opening or closing remarks of the attorneys, or the questions asked by the attorneys, only the answers given by the witnesses. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions or reach conclusions. You should not be particularly concerned about whether the evidence is direct or circumstantial, but I am going to define this for you. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Now, as jurors, you must determine the credibility of witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you were able to observe it. Now, testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that's not common knowledge or known to the average citizen. The law permits witnesses to give their opinions based upon that training and experience. You're not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. To impeach a witness is to show that witness is unworthy of belief. A witness may be impeached by disproving the facts to which that witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for an inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, the jury must apply your common sense and reason to decide what testimony you will believe or what testimony you do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant has made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised. These statements were not given in custody. So you can disregard that last sentence. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions of promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under any compulsion or necessity imposed by others. Now, this defendant is charged with crimes against the laws of this state. A crime is simply a violation of a statute of the state in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of the words, conduct, demeanor, motive, or other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will. A person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. Now, you should know every party to a crime may be charged with and convicted of the commission of a crime. A person is directly a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of that crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of this defendant that the crimes alleged here were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that this defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help, or was not a conspirator in the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime charged here was being committed, and that the defendant knowingly, intentionally participated or helped in the commission of it, you would be authorized to convict. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of, consent in, and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Now, members of the jury, the law of our state sets a time limit upon the state in starting the prosecution of most criminal offenses. The accused is on trial for the offenses of murder, aggravated assault, cruelty to children in the first and second degree. Under Georgia law, there is no statute of limitations for any of the types of murder charged. However, prosecution for the offenses of aggravated assault, cruelty to children in the first degree, and cruelty to children in the second degree must begin within 4 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit this defendant. The law provides that criminal actions shall be tried in the county in which the crime was committed. We call that the venue. That's the crime was committed in Housing County. And that's a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue may be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. All right, let's talk about the specific charges. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be malice murder. Malice, as a term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove. If the killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive that's been admitted for your use in determining the defendant's state of mind at the time of the killing. All right, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. So I want to define cruelty to children for you, and that would be the same definition for Count 2's felony murder portion and Count 3, which is the actual cruelty to children in the first degree. Okay, so I'm going to define that for you now. For cruelty to children in the first degree, the state must prove that the defendant maliciously caused cruel physical pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Count 4 charges felony murder with aggravated assault as the underlying felony, and Count 5 is the aggravated assault. I'm going to define aggravated assault for both of those. And felony murder is the same, right? And it caused the death and the commission of a felony. But in Counts 4 and 5, that underlying felony is aggravated assault. Okay? Aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon is any object that is likely to or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object charged here is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character and capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. Count 6 is murder in the second degree. For murder in the second degree, the state must prove that the defendant caused the death of another person by committing cruelty to children in the second degree. The state does not have to show that the defendant acted with malice in order to prove murder in the second degree. Cruelty to children in the second degree is the count number 7. I'm going to define that for you now, and that should also be the definition you use in considering count number 6, the murder of the second degree. Cruelty to children For cruelty to children, second degree, the state must prove that the defendant caused cruel physical pain to a child under 18 through criminal negligence. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the failure to act. Now, an accident is an event that occurs without the defendant planning, expecting, or anticipating it. You may not find the defendant guilty of a crime if the alleged criminal act was committed by accident and there was no criminal scheme, criminal intent, or criminal negligence by this defendant. I want to define criminal negligence for you in this context. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by that failure to act. If the defendant raises the defense of accident, the state has the burden to disprove the accident beyond a reasonable doubt. All right. You must reach a verdict as to, let me try again. If after considering the testimony and the evidence produced to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Houston County, Georgia, did on or between November 15th through 17th of 2020 commit one, some, or all of the offenses as alleged in this indictment, then you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we the jury as to whichever counts, find the defendant guilty. If you do not believe that the defendant is guilty of one, some, or any of these offenses as alleged, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant. In which event, the form of your verdict would be, we, the jury, as to whichever counts, find the defendant not guilty. A conviction on one count of the indictment does not require there be a conviction on other counts. It is the duty of the jury to consider each charge of the indictment separately. Now, by no ruling or comment that the court has made during the progress of this trial, have I intended to express any opinion on the facts of this case, the credibility of witnesses, the evidence, or the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the law given you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy to either side. You are only concerned with the guilt or innocence of the accused. You are not to concern yourself with punishment. That is an issue for the court in Georgia. Now, one of your first duties in the jury room will be to select one of your member to act as foreperson who will preside over your deliberations and sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another. Consider each other's views. Each of you must decide this case for yourself, but you should only do so after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, it must be unanimous, that is agreed to by all 12. It must be in writing, signed, and by your foreperson, dated, and returned to be published in open court. All that means, y'all, is I'm going to give you a verdict form. You're going to circle your verdict, guilty or not guilty, as to each count. You'll give it to the bailiff. I'll read it out loud once you're ready to do that. I'm going to let you retire from the jury room in just a second. I'm going to ask you not to begin your deliberations until you receive the indictment, the verdict form, and the evidence that's been admitted. If you have questions during the deliberations, they should be written down on a piece of paper, signed by your foreperson. You flip the light, the bailiff will bring them to me, and I'll respond to those. We've been at it a while, so I know y'all are going to need a break before you start your deliberations. Here is, let me give you a caveat about that. You can talk about the case only when all 12 of you are in the room. So if somebody's outside smoking or somebody's in the bathroom, you have to stop talking about the case until all 12 of you are back. So I'm going to let you retire to the jury room, take a break just a minute, don't start deliberating until all 12 of you are back in there. I have 2 alternates in this case. That's going to be Mr. Reuter, am I saying it right? Reuter, and, okay. So you guys will be in a separate room. You will not participate in deliberations unless that becomes necessary, okay? With that, y'all take a break, retire to the jury room, please.